Hi, welcome back. In this module of the course, what we're focusing on is restricting intrusive employer practices, meaning limiting what it is that the employer can do. And one of the best examples of that is the need to restrict an employer's own restriction on employee mobility. Now, what do I mean by that? Well, the fact is the hiring process is difficult. If you've made your way through the previous videos, you understand there's a lot to it. There are a lot of potential missteps that you can have along the way, and then of course the end result is you have an employee that may or may not be suitable for the job. So we know that the hiring process is difficult, and once an employer has a good employee, they will invest a great deal not just in finding their employees, but instead training them and teaching them and making them better employees. So employers invest a great deal of effort in finding and training employees. And therefore, employers would like to retain employees. It's an investment you make. And once you make the investment, you want to hold on to that. You don't want to see it simply walk out the door. However, from the employee perspective, the fact is that employees are interested in retaining the freedom to change jobs. Because the fact is that when you go out into the world, your first job or your second job, you don't know a lot. And you're going to learn a lot on the job, no matter what sort of training you've had in college or wherever. You are going to be a much better employee after a year or two on the job. And in fact, for some professions, such as the law, your most valuable point at any time in the practice of law is about 2 years into it, because now you've had exposure. You know how it works, you know how the court system works, you know how the client relationships work. So right at about 2 years, you've become much more valuable than you were the 2 years prior. And so you as an employee would like to be able to take that newfound training and knowledge and use it to improve your own situation by going to find another job, making a higher wage, whatever it is. So in this lecture, what we're going to look at are the means that employers use to retain employees and how it is that those means can be restricted by the law. Now, we'll start again with this fundamental idea. Most employers want to retain employees. When we were talking about the employment at will doctrine and this idea that employers can fire anyone for any reason they want as long as it's not prohibited by statute. Well, the fact is that even though employers have the freedom to fire employees for any reason, they usually don't. They want to retain their employees, especially if they put time and effort not just into finding the employees, but to training the employees. So most employers would like to retain employees. And one of the ways that they do that is that employees must sign some form of non-competition agreement. A non-competition agreement is an agreement that is going to restrict the ability of the employee to work for a competitor after the employment relationship has ended. Now, before we go on, we'll talk a little bit about the name. You've probably heard this referred to as a non-compete. That's the shorthand that we use in practice. But it has many names. And the thing to get about the non-competition agreement and why it's so extraordinary is that this is an agreement that has obligations that don't arise until after the employment relationship ends. So after the termination of the employment relationship, this agreement, which could date back years, maybe even decades, springs into existence and now is going to restrict an employee from doing whatever it is that they want to do. So the reason why these agreements are so controversial and why there is so much discussion in this area, and in fact, this is where I do my research for the most part, is on non-competition agreements and the enforceability of non-competition agreements, because they are an agreement that effectively gives to your former employer a monopoly over you, over your services. We grant this temporary monopoly to a previous employer, and that monopoly is going to restrict what it is that you can do as an employee. So it's an agreement in which an employee agrees not to compete with his employer after employment ends. So an agreement that doesn't come into existence until after the termination of the employment relationship. Now, the non-compete agreements adds limitations to an employment contract. We generally see non-competition agreements in two different situations. The first being after termination of employment, meaning it's going to apply to an employee after they leave their job, or in conjunction with the sale of a business. Now, the first of these, involving employment, is the area that we're going to focus on in here, and it is the area in which there is most controversy or discussion. And you can see the reason why. Now, in conjunction with the sale of a business, what happens is that a person sells a business to a new party, and that new party, that buyer, wants some assurance that the seller of the business won't simply turn around and start a new business doing the same thing. I had a good friend of mine when I was in practice, and this friend of mine had always wanted to be in business for himself. He had never actually been in business, so he went out and started looking for a business to buy, and he wanted something that would kind of run on its own and that he didn't really have to take a day-to-day management of it. And so he winds up buying a business that does rehab for apartments. Apartments, come on the market before they can be made available to potential tenants. Someone has to go in and patch the holes in the wall and shampoo the carpets and paint if necessary. And so this was the business, and the business seemed to be working just fine. They had a number of contracts with different apartment complexes, and they had a key employee who was there to manage the work crews. And so for my friend, he felt like this was a perfect example of a business that he wouldn't have to take a real active role in running and could instead simply rely on these employees. Well, what happened is they used a non-competition agreement that was not effective, not enforceable in the state of Texas, the danger of downloading forms from the internet. And what wound up happening is the owner of the business almost immediately, within a few months, started a new competing business. As those contracts with the apartment complexes expired, the new business, the old business's owner, who's now in the new business, comes in and renegotiates those deals, because that's where the relationship exists. That's where the relationship was that led to that contract in the first place. So when we talk about in conjunction with the sale of business, we are much more restricted in what it is that in terms of enforceability. We are going to be focused on after termination of employment. Now, historically, courts did not like non-competition agreements. We saw multiple examples of this over the years. Once upon a time, courts refused to enforce non-compete agreements because the idea was we should allow people to earn a living. We should allow people to work, and that it's a restraint of trade. It's a monopoly that shouldn't exist. But beginning in the late 19th century, this all began to change. And it began to change because of this doctrine of freedom of contract. And you might again remember freedom of contract from the ideas of employment at will. Freedom of contract means the party should be able to contract to whatever term they want to contract to. So in the late 1800s, we saw this focus on freedom of contract start to change the manner of dealing with non-competition agreements. It became such that people were given the chance. If you don't want to sign the non-competition agreement, don't do it. Go get another job. Find another job. But as with employment at will, we can see this led to some real issues. Now, in the Industrial Revolution is when we saw the first routine enforcement of non-competition agreements. Again, under the freedom of contract framework, the employer had a right to protect its interest. And you had a right to protect your human capital in the same way that you protected your other assets of the business by entering into these non-competition agreements. And courts gave to employers and employees the right to contract to whatever they wanted to contract to, with the idea that if enough employees felt like this was a bad idea to sign the non-competition agreement, the employer would be forced to change or modify or simply not use the agreement. Employers sometimes use different types of contracts to reach the same result. Now, the base model we're talking about is non-compete agreements, but there are other agreements that, although they are not styled non-competition or non-compete agreements, they wind up doing the same thing. So, for instance, there are non-solicitation agreements. And what these agreements say is that when you leave a job, you are prohibited from soliciting customers. Any customers of the firm, you can't go out and use them to build your new firm. You can't use that knowledge of customer base for your new competitor. So a non-solicitation agreement, although it's not a non-compete, can have the same effect. There are also non-solicitation agreements aimed at fellow employees in which you agree not to leave a job and hire one of your fellow employees in order to compete against your previous employer. This happens a lot in the professional field. Again, in the practice of law, oftentimes what will happen is that a lawyer will change firms, and that lawyer will then take her associates who had worked with her at the previous firm and her administrative assistant that had worked at the previous firm and the paralegal who had worked at the previous firm and take them all to the new firm. And a non-solicitation agreement would prevent that sort of poaching. And finally, trade secrets agreements and trade secrets is more than simply technical matters or that sort of intellectual property. Trade secrets could be things like price list, customer lists, any sort of confidential information that if it was possessed by another company would give to that other company an unfair advantage.